After almost 14 years of heated debate and rallies, the RH law has finally been declared as constitutional by the Supreme Court on April 8, Tuesday.
The RH law is not unconstitutional.
The announcement came after a deliberation amongst the Supreme Court justices who unanimously voted declaring the law as constitutional, save for some provisions that have been nullified. RH law supporters consider this proclamation as a major win in their cause in providing a better life for all Filipino women by bringing reproductive health education and services to millions of women, as stated in the core provisions of the law that were left untouched.
With a proactive Department of Health that recognizes the need, especially the plight of women, those services should really be provided. But precisely why we wanted to have this law passed is to ensure that for the future, kasi ngayon ho na nagwagi no, ang RH advocates at naging constitutional ang RH law, baka naman kumalat ho ang mga maling mga kwento-kwento tungkol sa RH law. Number one, hindi nga pinopromote nito ang abortion. Number two, ang effect nito is for every family. Pero ang macro effect nito, makikita talaga natin over time.
These core provisions include providing free reproductive health services to the public, including the marginalized sectors, as well as providing education through nationwide multimedia campaign and through appropriate health education in all schools. With the constitutionality of the RH law announced, how now will its implementing rules and regulations be executed? With the more controversial provisions such as providing sex education to schools left untouched by the SC, how will this be accepted by parents and implemented by the assigned government offices? And what will be the next steps for the RH law? Good evening. You are watching Legal Help Desk on the Solar News Channel. This show is about making the law work for you by giving legal advice on topics that matter to you. I'm Attorney Karen Jimeno.
And I'm Attorney Rod Nepomuceno. Tonight we will discuss the recent declaration of the Supreme Court on the constitutionality of the RH law. Our guests for tonight are some of those who have fought for the passing and implementation of the Act for years.
Our guests for tonight are Attorney Edsel Lagman, former representative of the 1st District of Albay, and Attorney Claire Padilla, founder and executive director of Engender Rights. Good evening.
Good evening.
Good evening.
And congratulations for your recent victory in the
Yes,
Supreme Court.
Attorney Claire. Yeah, so thank you for being with us. I know these are probably busy times because, well, now of course, in a way you're celebrating the victory that you had with the recent decision of the Supreme Court. But even with this decision, a lot of questions arose, no? Because there are several provisions that were struck down or that was considered or ruled unconstitutional by the Supreme Court, and we'd like to have some clarity on those matters.
Attorney Lagman can give us a quick run-through of what provisions were struck down by the Supreme Court.
Karen, before I give you an enumeration of the voided provisions, let me just caution that we should not have undue fascination over exceptions and fail to see and appreciate the general rule. Because the general rule, according to the Supreme Court, the RH law is constitutional except for some provisions which were voided, principally to respect minority or differing views. Now, let me go to the voided provisions. There are about 3 or 4 groupings. One is with respect to the consensus objectors. And this would include hospitals owned by religious groups which are not required to refer the patient to another hospital which is willing to give reproductive health care and services. Number 2, with respect to healthcare providers who, because of religious belief, would object to following the law by giving medical care, they are also exempted from liability according to the Supreme Court. And third in this group would be private healthcare providers who will not be required to render 40-hour pro bono service a year to indigent patients if they are consensus objectors. But let me just caution also that the consensus objection is not an absolute license to violate the law. A consensus objector must base his resistance on good faith.
In good faith. So, Attorney Edsel, I was reading, thanks for bringing a copy of the Supreme Court decision here. I was reading it before we started. And sa madaling sabi, the first group that you enumerated just now are those either healthcare providers or hospitals who, because of their religious belief, refuse to refer another healthcare provider or another hospital when you need assistance that would require certain services under the RH law. But I think I saw here that it's because it violates religious freedom.
Well, that is the justification. And but in other jurisdiction, you know, a pharmacist, for example, cannot refuse to sell or dispense the prescribed contraceptives because of religious beliefs.
No, Attorney.
According to this decision, their oath of office should prevail over their own their religious belief. But that is beside the point now, because the Supreme Court said religious objectors will be free from liability.
Oh, Attorney Claire, I just want to clarify. At least insofar as you're concerned, do you think that these provisions that were considered unconstitutional, do you think overall it had an impact on it has an impact on your position regarding the RH law? Do you think that they're fatal in a way, or do you think that you're all right with it? You're all right with these struck down provisions?
First, generally I would say that the provisions that were struck down do not generally affect the RH law, because in the entirety you still have the provisions that were actually questioned by the anti-RH groups. So we won in terms of having a national law that was passed that specifically pointed out provisions for reproductive health care, reproductive information. So the provisions that they wanted to be taken out with regard to reproductive health education is still there. We have, for example, the DOH, they are required to procure contraceptives and collaborate with local government units. The provision on public awareness in terms of reproductive health is there. We have provisions, for example, on the inclusion of contraceptives, especially hormonal contraceptives, injectables, IUD, in the essential drugs list. And a drug can only be removed if any drug would be considered abortifacient. This would only be subject to the FDA determination.
So it's still the FDA who's going to decide that.
Right, but as far as we're concerned, given our research and medical scientific findings, we know that only abortifacients will really be classified as abortifacients, whereas contraceptives, emergency contraceptives, we are confident that all of these will be considered as contraceptives.
One of the major criticisms against the RH law before was that it allowed abortion, or it legalized abortion. But there's a portion in the Supreme Court decision that actually touched on that topic. And maybe, Attorney Lagman, you can clarify. So, ano ba talaga? What is the effect of the RH law in terms of the current law criminalizing abortion?
Oh, there were a number of issues raised by the petitioners. One would be with respect to the law being an abortion measure or would encourage abortion. That was negated by the Supreme Court. But the Supreme Court said that this is not an abortion measure, and the RH law protects even the unborn from conception. As a matter of fact, in the definition of what are abortive patients, we included a provision that an abortive patient is a drug or a device which would prevent the implantation of the fertilized ovum into the mother's uterus. That is a noble provision, not found in other statutes in most probably in other parts of the world, because abortion really would refer to expelling prematurely the fetus from the mother's womb. So according to the Supreme Court, this is a very clear indication that the RH law protects the unborn.
Thanks for clarifying that.
All right. So,
Karen,
go ahead.
Can I just include that what I like about the law is that it reiterated the Magna Carta of Women provision where there should be humane post-abortion care. Now, this is very important because regardless of the revised penal code provisions, it basically says that medical providers should attend to people who induce abortion. And it also relates to RE 8344, which basically provides that, for example, if a woman comes to the hospital bleeding, they should stabilize the woman first. So that means that they cannot threaten them and say that, we would file a case against you, because threatening actually discourages women in going to the hospitals. So this is a strong statement in terms of even providing post-abortion care for women who induced abortion.
So for those who, for instance, violate the law by getting an illegal abortion, will still have the right to life by going to health centers or hospitals to get the post-abortive saving measures.
Right.
What about if there's a conflict between the life of the mother and the life of an unborn child? What was the court's decision with respect to getting voluntary abortion to save the life of a mother?
Well, the court did not specifically address that question directly, but there were passing comments that in case there is a need to decide whose life should be saved, the mother's or the child or the fetus, then the courts deferred to the medical professionals to make the necessary decision. Well, I think there's also need to tell the public what are the other groupings of voided provisions.
Okay.
The second group would be with respect to parental and spousal consent. With respect to spousal consent, according to the court, in case of married couples, one cannot have a ligation or a vasectomy without the consent of the other. But this is more the exception than the rule, I tell you, Karen, Rad. Because in most cases, in a conservative Filipino family, the spouses would discuss this matter, whether or not one should have a ligation or a vasectomy, particularly so when it is medically recommended or they have already children. In other words, that what was struck down was more of an exception when the husband, most particularly husband, would refuse to give the consent. But that is more the exception than the rule. Now, with respect to parental consent, there are two areas there. One, that minors would have to get the consent of their parents in order to access modern contraceptives. And the law as originally formulated made two exceptions. When the minor is already a parent or when the minor had already a miscarriage. The Supreme Court struck down the second exception.
So in other words, if you had,
a minor girl who had a miscarriage would still have to get the parental consent in order to access modern contraceptives. Does not say all kinds of reproductive health services, because the law limits it to modern
So
contraception.
Modern
to remove all,
contraceptives.
I guess, thoughts, no, or presumptions of certain people that this law will provide free access to young people, free condoms and contraceptives. That's not going to be the case, right? They would need to.
Well, as provided for by the law, minors
Minors,
should get the parental consent in order to access modern
Right.
contraceptives.
Right.
Mm-hmm.
So
Any
it's-
definition on what modern contraceptives include? Does that include condoms, intrauterine device?
The law did not attempt to define contraceptives. It defined abortifacients, but not contraceptives, because this is a continuing technology.
All right. We have a couple of questions from our viewers. Let's answer these with the help of our guests, of course. This question is from Kiko. Is it possible for the Supreme Court to overturn its decision regarding the RH law if ever the anti-RH law supporters would file a motion for reconsideration?
That is virtually nil, because the Supreme Court decision is unanimous. In order for the anti-RH forces to get a reversal, they should be able to convince 8 justices to reverse their respective positions, and that is very hard to do. That's virtually impossible.
Also, I guess to add to that, for an MR to prosper, you have to have very specific grounds. It's not as a matter of right granted, right? The
That's
MR.
correct. That's correct.
Okay,
Right.
we have another question from Elaine. What are the possible negative effects of the new RH law, and what are the confirmed benefits of the law to women?
Karen, let me just point out that in terms of negative effects, I'd like to answer the question in a manner wherein to clearly state that although the penalties, some of the penalties were struck down, I'd like to state that this does not provide a license for doctors, for example, to say that it doesn't require doctors to require, for example, spousal consent. So it only means that, for example, a doctor refuses, that there's no penalty. So this would be in cases of, for example, those who tried to oppose the law before. But the general practice is that many doctors do not require spousal consent in terms of, for example, ligation. There are even some doctors who do not require consent of the child, for example, in terms of providing for contraceptives. So I'd just like to point out that even if the law the decision struck down some of the penalties, this is only with regard to those who will use their conscientious objection. But as pointed out by Representative Lagman, one of the dissenting opinion was that the issue on religious refusal is actually an imposition of a major religion to some of those women who would try to access reproductive health care. And this is Justice Leon, and he's basically saying that because of this, it also sort of propagates patriarchy and sexism. For example, when a doctor is given the doctor's conscientious objection, basically he's saying that this propagates sexism and patriarchy. In our work as women's rights activists, we are saying that there are instances that there would be abused women who would definitely not get the consent of their husbands because their husbands would threaten them to, they would threaten to beat them, they would beat them, or they would threaten to leave them, as in some of the cases that we have.
And it seems like one of the negative effects of requiring this consent from a spouse is that if you're legally separated, this is the type of spouse who will not give the consent or mahirap hingian ng consent. So you're basically making any other procedure sort of inaccessible or impractical for that person.
Like for legal separated couples, I would say that that would be an exception to the decision. The problem would be for people who are separated de facto, who are separated in fact.
Yeah, who are just separated
Right.
but not legally separated.
Not legally separated.
Under the
Right.
law, you still need spousal consent.
spousal
You're
consent,
going to get a
right.
ligation. Or,
Right.
yeah.
So to me, this is a a diminution of the rights of women. It undermines the rights of women in terms of deciding for their own bodies. So definitely, in terms of gender rights, this is a setback. So that's why we would go to the grassroots and talk to women to really enforce their rights in terms of not really getting spousal consent. So in other words, getting doctors who would not require spousal consent in terms of ligation.
But I guess, just to answer that question quickly, benefits would include, again, having access to family planning services
Right.
and getting age-appropriate sex education, among others. We'll discuss the rest of the benefits as we go along the provisions. For now, we'll take a short break and we will return. We'll discuss more on the RH law with our guests. Keep it here on the Solar News Channel. You're still watching Legal Help Desk on the Solar News Channel with our guests, Attorney Edsel Lagman, former representative of the 1st District of Albay, and Gender Rights Executive Director, Attorney Claire Padilla.
Okay, so just before the break, we were talking about the provision requiring spousal consent in cases, for example, when a woman wants to have a ligation, and we have situations wherein one, as you mentioned earlier, she's legally separated, and obviously it might be impractical or might not even be relevant for her to get spousal consent. But in situations where there's just been a de facto separation or physical separation, in that scenario, will a woman who gets a ligation without spousal consent, is there any penalty on to her, insofar as she's concerned?
So there's no penalty for doctors who will not require spousal consent. There's no penalty for the woman who can get access to a ligation without spousal consent.
Right.
So let's
Okay.
make
So
that
let's
clear.
make that clear.
However, it allows doctors who will invoke conscientious objection to refuse to require spousal consent, and there's no penalty for them. But personally, I have an opposing view on that. However, so what we're basically saying is that the practice has not changed. It only allows certain doctors who will invoke conscientious objection that there's no penalty. But just to show that in other countries, for example, apart from pharmacists, there have been hospitals who have been made liable, for example, for refusing to provide emergency contraception. So this means that in a certain time, we can actually change the decision of the Supreme Court, perhaps in a few years, or perhaps even the law itself. So it can we can even impose at a certain point that there can be penalties still. So there's still a possibility. Plus, there are existing laws, for example, where you can still make certain medical health professionals liable for damages. So there are possibilities wherein you will have cases where people will invoke their right to medical health care, public health, and there's no provision in the law or in the decision which does not allow civil case for damages, for example. So there's always a possibility.
You can still file a case.
Well, the decision of the Supreme Court with respect to some voided provisions can be subject to a legislative enactment, a remedial measure. For example, with respect to spousal consent, then a law can be passed that in certain circumstances, spousal consent is not necessary. And you enumerate the circumstances. Because to my mind, a woman is not a woman if she does not control her own body.
That's a very good statement, Attorney Lagman. Now, with respect to parents who are concerned na baka magka-access bigla yung mga anak nila to contraceptives or easier access. If, for instance, you mentioned earlier that minors, certain types of minors, are required to get the consent of the parents in order to obtain modern contraceptives. If a parent finds their child having those types of contraceptives and they were able to obtain it basically through under the law without getting their consent, would the provider be liable under the RH law, or would kanino pwedeng mag-complain, or kanino pwedeng sino yung pwedeng ireklamo nung parents in that case?
There is no specific provision imposing a penalty. And we all know that if there is no provision on a penalty cannot be imposed. But I think this particular problem will be solved by the provision on RH education. Because that was not struck down by the Supreme Court. It's still there. It has been saved from the judicial scalpel, so to speak. So that provision would be able to teach minors, adolescents, on proper sexual values and on the need to avoid multiple partners, on the need to avoid intimate sexual relations before marriage. That those will all be covered by the sexuality or reproductive health education. So, in other words, adolescents will not be anymore be curious to experiment because they are already informed on what are the pros and cons and what are the adverse consequences
So you're saying
premature sexual relation.
So you're saying the lack of penalties for having access without the consent of the parents to some types of contraceptives can be equalized by the sex education, age-appropriate sex education that the RH law provides.
That's correct.
Now, one of the arguments, of course, of some sectors is that this law seems to encourage promiscuity because you can then have, I guess, total access to as much. I mean, I quote some people who are literally saying, I don't want my son or daughter, teenage daughter, to go to a public health facility and get as many condoms as she can. Is that
right?
Is that the situation?
That is more of a malicious speculation,
right.
than a factual assertion.
Okay, it's good you're clarifying it.
The empirical studies in the United States by the United Nations and other progressive countries will show that there are so many beneficent effects of reproductive health education among the young. It inculcates proper sex values. It avoids multiple partners. It encourages abstinence before marriage, and also would prevent the spread of sexually transmitted diseases. So we are not going to breed minors into promiscuous young adults, but we are going to give them the proper sexual and orientation, and that would even also impart on them that abortion is illegal and prescribed.
Okay.
But let me say, before we end this particular discussion on reproductive health education, that the law, if you read the law does not distinguish whether an adolescent is enrolled in a public or private school.
So if you have a very strict Roman Catholic school refusing to provide sex education, will they be penalized under the RH law?
Well, let me just continue, because adolescents in private schools, more particularly sectarian schools, should not be deprived of the benefits of reproductive health education. Otherwise, there will be a violation of the Equal Protection Clause. Now, whether those schools which would not provide for reproductive health education to their adolescent students, then I think there's a provision in the law which says it's a general provision, any violation.
Section 24.
Yeah, any violation. And that could be a violation. But I think the Supreme Court will have to rule on this because according to the Supreme Court, it is still premature to rule on the various aspects of sexuality education.
What about parents who opt out? What if they're sending their kids to a certain school and then they say, I refuse to allow my child to attend those sex education classes?
Well, actually, I would think that in those cases, the best interest of the child would prevail. So because specifically you would have the RH law saying that adolescents should have access to reproductive health education, I don't think that any, for example, case that's filed by a parent would prosper in that sense. So strongly, I would argue that that would not be allowed under the RH law because there are no exceptions under the law. So basically, it's not feasible. And just to add what was mentioned earlier, apart from the general provision on penal provision in terms of religious schools, I would say that they could still be made liable under civil case for damages. So that's a possibility as well. But just to add, there have been private Catholic schools that have been holding their own reproductive health, sex education, sexuality education throughout the country. So we actually submitted that with the Supreme Court, and they are aware that there have been public schools and private religious schools that have been implementing RH education in the past.
Now, there are aspects also of the law, though. I mean, again, there are some sectors who are saying that this is a population control measure, and they're allergic to hearing that, you know, because of maybe the religious beliefs. Can you clarify again? Is this a population control measure?
Definitely
it's not a population control measure. One, no less than the law. I think Section 3, letter L, said that there shall be no demographic or population targets. The mitigation and promotion and stabilization of the population growth rate is incidental to the advancement of reproductive health. What does that mean? One, the law does not impose any rate or range of population growth.
Not like in China's one-child policy.
Not like in China or other countries, for example. So definitely there is no population control. And secondly, it says that if ever there will be a deceleration of the population growth rate, it would be the effect of giving parents, couples and women the opportunity to fully exercise their right to freely and responsibly determine the number of their children. Another reason why there is no population is that a population control measure. Population control is anathema to the hallmark of the reproductive health law, which is freedom of informed choice.
All right.
And then I guess to add to that, actually the law has a provision which provides services to couples who want to be fertile or who want to have kids.
That's correct.
All right. All right. So we have a couple more questions from our televiewers. Marie Chris asks, how will the government explain the law to Filipinos who do not fully understand the law, and like those in slum areas, for example, in the far provinces or the minority groups? How will you go about and spread, apart from, I guess, what you're doing now in media, how will you reach them?
I think in terms of the government, you have the barangay health workers, you have the midwives, for example. And what is important to stress about the law is that it does not only provide reproductive health education and the procurement, but it also extends services. For example, in terms of the midwives, now under this law, they're allowed to dispense oxytocin, and these are important in terms of treating postpartum hemorrhage. So for women, for example, who have already given birth, but their placenta is stuck, for example, they would bleed. In far-flung areas, this law actually maintains that midwives are allowed to dispense oxytocin, magnesium sulfate, when there are no doctors. So this, it's important for women to know that the law is important. It talks about childbirth. It talks about maternal care, not just access to contraceptives, not just reproductive health education, but even proper health care in terms of safe delivery and safe motherhood. So that's very, very important. So to me, that can be said in a lot of far-flung areas in the Philippines.
And let me also say that one of the core provisions not struck down by the Supreme Court is with respect to Section 20 on public awareness and a massive nationwide multimedia campaign for the protection and promotion of reproductive health. That one is very important, and that would answer the question, how are you going to explain to the masses of our people the benefits, the pros and cons of family planning and reproductive health? And the explanation will not be very difficult to deliver, because no less than the marginalized women in several surveys said that they want to limit the number of their children, but the problem is they do not have access to reproductive health information and services, and now the government will do that for them.
All right.
That's great to hear.
Now, just to clarify, everyone seems to be saying about when you say reproductive health, it's focusing on women. It's also reproductive health of men, right?
That's
correct. So it covers both.
Men and women.
Yeah. Now, from a macroeconomic perspective, how do you see this impacting our economy and the general well-being of people moving forward?
Well, in case of, for example, for women, I would say that a lot of women would be able to finish college, because a lot of them in the past, because of restriction of access to contraceptives, they've only been able to finish first-year high school. So in terms of having women empowered, having women being employed, having their own careers, women being able to manage their fertility, being able to feed their children, even, for example, the cycle of having adolescent pregnancies, this can actually change. So you would have more people educated, more people in the workforce that are actually having the jobs that they really want, for example. So in that sense, with empowered women, empowered adolescents, empowered men as well, we would have people who are having success stories in terms of having financially sustainable jobs, I would say. So that would help our economy as
Attorney Edsel, Attorney Claire mentioned empowered men. How do you think the RH law empowers men?
Well, the men and women are both beneficiaries of the RH law. Well, it's more really of empowering women, because they bear the burden of pregnancy, childbirth, and child rearing. But it is also a reminder to men that they should be able to appreciate their wives, who really carries all of this burden, and in such a way that men should be able to complement the empowerment of their women rather than oppose such a development. Now, let me also say that more than population control measure, the RH law is a poverty alleviation legislation and also prescribes ways by which government could achieve sustainable human development. And on the macro level, that would be an effective result of the full and faithful implementation of the reproductive health law.
Very inspiring. So at least it's a law that empowers both men and women, hindi lang siya one-sided. And actually it also promotes family by allowing couples to get fertility services if they can.
I think what's important is
want
we're able to discuss this in detail and be able to provide the information that people need and want, no? Rather than just making quick judgments on a law.
There is one core provision yet we have not mentioned. It's the provision which is spread over the law that local government units are mandated to assist the national government in the implementation of the law. This has not been touched. This has not been voided by the Supreme Court.
All
Okay,
right.
thank you.
Okay.
So we, I guess, have to discuss more, but we'd like to thank our guests before we take a break. Thank you, Attorney Edsel Lagman and Attorney Claire. Thank you
Thanks
so much
so
for being
much.
with
You
us
provided
tonight.
a lot of information. I'm sure our televiewers appreciated that.
And yeah, and the
able to-
Supreme
yeah.
Court decision has not yet been published. It was very
Yes.
helpful that you were here to explain to us what the decision
Because this is now the law of the land, and we all have to respect it. Regardless of what your side is, this is now the law of the land, right?
Incidentally, the provision on misinformation has not been struck down.
Right, right.
So a public
Incorrect
official or a healthcare provider who makes incorrect and misinform
It's still
the
there.
public is still there. And that has been particularly discussed.
And there's a penal provision for that.
Yes,
Yes.
that's a federal
All right.
provision
It has been
that discussed in the ponencia of Justice Mendoza.
All right.
Thank you for
Thank you very much,
clarifying that. At least alam natin, if you're like a religious-based opposition to it, tapos you cannot misinform the public.
Right.
Because
In
you
other
can be
words,
penalized.
Failure to inform or failure to render
The right information.
The right
service
information, right.
is not punishable, but a misinformation on the facets of the law and the RH program is
Is punishable.
culpable.
Yes, even if it's religious-based.
Right.
Okay.
Culpable.
There's no exception.
Thank you once again. And
Thank you
for
very
now,
much.
we'll take a short break. Legal Help Desk will return, so stay tuned. Welcome back to Legal Help Desk on the Solar News Channel. And we just discussed the constitutionality of the RH law as declared by the Supreme Court last April 8, Tuesday.
You know, one of the great things about the show is that you really learn a lot also. As you know, we're lawyers and we keep ourselves up to date, but when you discuss with people like, of course, Representative Lagman and Attorney Claire, you get to the nitty-gritty
Yeah,
of things.
especially
and,
since
you know,
they were there from the start, meaning
Yeah.
they advocated
Yes.
for the law, and they have a copy of the Supreme Court decision, which was not available
Yeah,
until today. I mean, it's not been out to the public yet. And I guess what's important for everyone to know is that, one, because this law has been declared constitutional, it now applies, meaning the provisions of the RH law, no matter how controversial others deem it to be, it's now the law of the land. You were
and
right
in
earlier.
a way, it's in effect already because they removed the TRO, di ba? At the time, they had to suspend the law. So now, I guess we just wait for the implementation, the IRR, implementing rules and regulation. So it is part of the law now, and we'll have to respect it. And you know, just to summarize it, the provisions on the sex education is there.
And I guess one thing to highlight, especially for parents who are worrying, under the law, it's age-appropriate sex education. And this applies to both private and public schools.
Yes.
And as Attorney Lagman said kanina, It basically applies to all schools. So if you're a parent and you don't want your child to undergo this type of sex education, Attorney Claire was saying it's actually impossible because it's going to be, it's required to be part of the curriculum in accordance with the RH law.
And of course, now the DOH is required to give all of the necessary facilities, facilities and of course contraceptives to the various public health offices and clinics all around the country. There is still the provision, of course, that any health officer who belongs to a religious group, let's say a hospital that's owned by a religious order, for example, and if they are being asked to provide, let's say, for contraceptives and it's against their conscience, they can still say no, but it has to be in the basis of, it's a conscientious decision. It's based on your good conscience, all right? So those will be on a case-to-case basis. Of course, we still don't have jurisprudence on that, but I guess we'll see how it pans out, how it gets implemented in cases like that.
And also, of course, for parents who are very worried if their kids, minor kids, will have access to contraceptives, there's actually a provision under the RH law which requires the consent of parents in order for minors to have access to modern contraceptives. And again, this law is not only about contraception or family planning, it's also family planning for those who want to have kids. So for couples out there, if you want to have kids and you need advice on fertility or services that will enable you to address fertility issues, the RH law allows you to have access to that even if you don't have the financial resources for it.
So hindi automatic na parang a teenager will just come in a public health office and get as many condoms as he can. That's not usually going to happen. It will still require parental consent, especially for minor. The exception, of course, if that teenager or that minor was already pregnant or already has a child. So in which case, yun ang exception to the parental consent. But otherwise, parental consent is still required. So there's still a lot of facets and details. We obviously suggest to our televiewers to read the law so that you will be more educated once it comes out and gets published. It should be available.
Yeah.
It should be available.
And of course, lastly, abortion is still illegal. The RH law did not legalize abortion.
Okay. All right. So that's the RH law. We have received some questions from our guests on topics we have previously discussed. This is a part where we will answer these questions. We'll start off with Imelda. I own a small sari-sari store in front of my house. I already submitted BIR form 1701 or 1701Q. Do I still need to submit form 1701? So the 1701Q is the
for the quarterly filings.
Quarterly, yes. Then 1701 is
for the annual tax returns.
So yeah, the answer is yes.
Yes.
Yeah. So basically, what happens in the 1701, you submit all of the quarterly forms that you had submitted the past quarters. Normally, the 1701 is the annual report, the annual return that you have to file. So,
Our next recap question is from Maritoni. Is it correct that those earning less than 100,000 pesos a year do not need to file their taxes? Does this pertain to single proprietors? What if we filed quarterly? Does this mean we don't have to file annually? So first of all, the 100,000 pesos, it relates to those taxpayers who are engaged in business. So
like
pag may sales, so in this case, and under our tax laws, if you're earning less than 100,000 pesos, you're considered a micro business and you don't need to file an annual income tax return. And if you've already filed your quarterly income tax returns, again, the general rule is that you still have to file an annual income tax return, except that if you fall under the exception, meaning na pagka your overall income for the whole year did not exceed 100,000 pesos.
And of course, just to differentiate, if you're employed naman, the rule is minimum wage. If you're getting less than minimum wage, you don't have to file an ITR.
Or in other words, if you're earning less than 60,000 pesos a year, then you don't have to file an annual income tax return. And of course, just because we're on the topic of taxes, it's already April 14. The deadline for filing
Naku,
your annual
tomorrow.
income tax return, reminder to all the viewers there, is already tomorrow,
Tomorrow na.
April 15. So don't forget.
Don't wait last minute. Well, it is last minute already. So, moving on to our next question. Says Astas, my friend wants to file a concubinage case against her husband who is now living with his mistress and in her house. The children are sent there on weekends to spend time with their father. Since it would be difficult for her to obtain evidences of them having sex, can the children be called as witnesses instead? Oh my gosh, the children
Actually, the question presumes that the children are witnesses to
the sex,
no?
which might be a little tough. But
Yeah.
however, they are cohabiting, right?
Yeah, so the good news
yeah.
to our viewer here is that, yes, you can file a case for concubinage against your husband because there are 3 types of acts that can constitute the crime of concubinage. And one of them is that cohabiting with the mistress in any other place. So even if the mistress does not live with you in your conjugal home, it is concubinage if your husband is cohabiting with the mistress. And under our law, children can be witnesses. So the requirement lang under the law is that witnesses should have the ability to make their perceptions known, to perceive and to make their perceptions known. So if your children actually are qualified and if they've really been exposed to the father and the mistress and have seen them together, and if they can say that they know in fact that they are living together in that house, then they can be witnesses for a case of concubinage against your husband.
I don't think they have to take pictures of them. No? That'll be a little tough. No? But and also if they're 4 years old, I don't think you can do that. But yeah, as you mentioned, yeah, the witnesses have to be someone who can perceive and could testify, later on. So that's. I hope that answers your question. Sadly, that's all the time that we have for tonight. We'd like to thank our viewers for sending us your questions via social media. Thank you for tuning in to Legal Help Desk. I'm Attorney Rod Nepomuceno.
And I'm Attorney Karen Jimeno. If you have any questions on our topic for tonight, you may share them with us on our Facebook and Twitter pages. If you've missed any episodes of Legal Help Desk, you can watch these on your mobile devices at your convenience. Download the Solar News mobile app on Google Play or Apple App Store. Join us again next Monday as we discuss your legal rights. Good night. Our guests for tonight are Attorney Edsel Lagman, former representative of the 1st District of Albay, and Attorney Claire Padilla, founder and executive director of Engender Rights. Good evening.
Good evening.
Good evening.
And congratulations for
you.
your recent victory in the
Yes,
Supreme Court.
Attorney Claire. Yeah, so thank you for being with us. I know these are probably busy times because, well, now of course, in a way you're celebrating the victory that you had with the recent decision of the Supreme Court. But even with this decision, a lot of questions arose, because there are several provisions that were struck down or that was considered or ruled unconstitutional by the Supreme Court, and we'd like to have some clarity on those matters.
Attorney Lagman can give us a quick run-through of what provisions were struck down by the Supreme Court.
Karen, before I give you an enumeration of the voided provisions, let me just caution that we should not have undue fascination over exceptions and fail to see and appreciate the general rule. Because the general rule, according to the Supreme Court, the RH law is constitutional except for some provisions which were voided, principally to respect minority or differing views. Now, let me go to the voided provisions. There are about 3 or 4 groupings. One is with respect to the consensus objectors. And this would include hospitals owned by religious groups which are not required to refer the patient to another hospital which is willing to give reproductive health care and services. Number two, with respect to healthcare providers who, because of
RH Law supporters consider this proclamation as a major win in their cause in providing a better life for all Filipino women by bringing reproductive health education and services to millions of women, as stated in the core provisions of the law that were left untouched.
With a proactive Department of Health that recognizes the need, especially the plight of women, those services should really be provided. But precisely why we wanted to have this law passed is to ensure that for the future, kasi ngayon huna nagwagi no ang RH advocates at naging constitutional ang RH law, baka naman kumalat ho ang mga maling mga kwento-kwento tungkol sa RH law. Number one, hindi nga pinopromote nito ang abortion. Number two, ang effect nito is for every family. Pero ang macro effect nito, makikita talaga natin over time.
These core provisions include providing free reproductive health services to the public, including the After almost 14 years of heated debate and rallies, the RH law has finally been declared as constitutional by the Supreme Court on April 8, Tuesday.
The RH law is not unconstitutional.
The announcement came after a deliberation amongst the Supreme Court justices who unanimously voted declaring the law as constitutional, save for some provisions that have been nullified. The marginalized sectors, as well as providing education through nationwide multimedia campaign and through appropriate health education in all schools. With the constitutionality of the RH law announced, how now will its implementing rules and regulations be executed? With the more controversial provisions such as providing sex education to schools left untouched by the SC, how will this be accepted by parents and implemented by the assigned government offices? And what will be the next steps for the RH law? Good evening. You are watching Legal Help Desk on the Solar News Channel. This show is about making the law work for you by giving legal advice on topics that matter to you. I'm Attorney Karen Jimeno.
And I'm Attorney Rod Nepomuceno. Tonight, we will discuss the recent declaration of the Supreme Court on the constitutionality of the RH law. Our guests for tonight are some of those who have fought for the passing and implementation of the Act for years.